Hello, good night. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer your questions. So tonight I have a great topic to talk to you about. I am going to talk to you about adjusting status in the United States. What does this mean? Who qualifies for it? Now, this is a very popular topic. So if you're looking to gain status in the United States, get permanent resident while staying in the United States, you're going to want to hear this. Now, in the meantime, I also want you to know that you can put your comments in your questions in the comments, and I will answer your questions. I'm monitoring the comments both on YouTube and on TikTok. And so as soon as your comments start to come in with your questions, I will prioritize those and answer your questions. Now I want to talk about who qualifies for adjusting status in the United States. What is adjusting status in the United States? It is the process of applying for permanent residence while staying in the United States, and you don't have to leave. And yes, even some individuals who are currently out of status or have no status can apply for this, for permanent residence while staying in the United States through adjustment of status. Ainat, thanks so much for sharing the live. I appreciate it. And with that, I'm going to also say, go ahead, share this live, because I'm here to share information with individuals who need assistance like this. So go ahead, share my live so that others can learn this information as well. Now, go ahead, put your questions in the comments, and it does not have to be related to the topic that I'm talking about tonight. So Amanda, thanks so much for sharing. I appreciate it. Now, who qualifies for applying for the green card while staying in the United States? And this adjustment of status, by the way, offers benefits. So while you're staying in the United States, you can apply for your work permit and your travel document. That will give you some reassuring relief while you wait in the US for your permanent residence approval. So who qualifies? So one, an individual who currently holds status, who has an approved I-130 and an immigrant visa number available to them. That means that their priority date is current. That means that they're currently processing your dates. So it's usually on your receipt notice, so the date on your receipt notice and before. That means your priority date is current, and that means that you will likely, if you're in the United States, you will likely be able to qualify for adjustment of status. That is the process of submitting a special application that allows you to stay in the United States, attend your permanent residence interview in the United States, and then obtain permanent residence here. Now, who qualifies? Now, even though you may have your status, and you have an approved I-130 or an I-140. This is a petition through an employer. So this not only applies to family, it also applies to employment. Sponsorship through employment may allow you to adjust status as long as you can meet these requirements. All right, so I see a question. I'm going to take pause to answer that question. So what if the person lost their ID and need to apply for status? How does one process? So if you have lost your ID, there is a way. So usually when you're adjusting status, you will have your passport. So you can, and it depends on what evidence is required. But if you're going through adjustment of status, it's likely that you will need your birth certificate and your passport. If you've lost your passport, you would be able to submit copies if you do have copies. If you don't, you will definitely need to apply for your passport through your country. And there are ways to stay in the US and apply for your passport. So now, I don't know your particular situation, Feli Am, but that's where you'll have to make sure that you schedule a personal consultation to get personal legal advice. But if you've lost your ID, you have to first check to see how you can get that ID replaced. So U status can apply. So MAMTA, absolutely. U visa, those who have U status can apply for adjustment of status in the United States, but you want to make sure that your process is going to be a straightforward process. That means that you are going to, you don't have any inadmissibilities. Inadmissibilities mean that you don't have any previous adjustment of status issues. You don't have any criminal issues. But even if you do, you will be able to. Okay. So even if you do, thanks so much for the love. Even if you do, you would be able to apply for a waiver. That means apply for the forgiveness. So it's very important that you schedule a consultation if you have U status to make sure that you meet all the requirements for adjustment of status. So Feli you're asking for a friend. Make sure you give your friend my information so that I can schedule a consultation. So, hi, ma'am, my junior bro and sis green card is missing. The green card was tracked and it shows. And Miss Smiles one, I'm not seeing the rest. You may be saying it shows that it's delivered. In that case, you will likely have to apply for it to be replaced. Do you advise that person's OPT to switch from F2B to F1 if that category is more current? So Ainata, that is a little more detailed. You want to get legal advice about that. So when you're switching status, so if you have OPT and you do qualify to switch to another status, then you would be able to do it. But in this case, you want to make sure that you get a personal consultation to determine whether you qualify. So it has been delivered in our mailbox, but we didn't see it. We have called the various offices in charge and they say it has been delivered already. So Miss Smiles, usually when you're in a situation like this, it means that you will have to reapply. So if they say it's delivered, you haven't received it, it means that you're going to have to apply for a replacement. Now, if the USCIS determines that it is their fault, they usually replace it without applying for without an additional fee. But in this case, if they say that it shows as delivered, then they're likely going to require a fee to reapply for that permanent resident card. So my question is, my dad can file for citizenship directly for them since he is a U.S. citizen and they are below 18. Sorry for the long write-up. So it depends. So let's see. So if your dad has become a U.S. citizen and they are under 18, and they were within the custody of your dad, then it could very well be that they are already U.S. citizens, and you just have to apply for evidence that they are U.S. citizens through getting the N600, or even by applying directly for their passport. So okay, I just lost connection, but I am back. So they could apply if they have derived citizenship, they could apply, but I would have to determine whether they have derived citizenship by in a consultation. But it is possible that they have already obtained citizenship through your dad after becoming permanent residents. And in that case, you would want to make sure that they apply for proof that they're U.S. citizenships, either through applying for through the N600 to get a certificate of naturalization, or by just applying for the passport. All right. So keep those questions coming. I am here to answer your questions, and so go ahead and keep those questions coming. All right. All right, so now I'm talking about who qualifies to apply for adjustment of status. And the individuals who qualify are either if so you're maintaining legal status, you have received an approved petition. This could be an approved petition through an employer, for example, an approved petition through humanitarian, like a U visa, or it could be through a family petition. And then also your immigrant visa number is current. That means that they are currently processing based on your priority date. If these conditions match and you are currently holding legal status in the United States, then you would be able to adjust status in the United States. Now, there are exceptions. What if you're out of status? There are exceptions here. And the exceptions here are if you're the immediate relative of a U.S. citizen. Immediate relatives of U.S. citizens, though, is not every relative of a U.S. citizen. It's a spouse of a U.S. citizen, a parent of a U.S. citizen, and that U.S. citizen is 21 and up, or a U.S. citizen's son, or you're the parent, you are the son or daughter of a U.S. citizen who is under 21 and unmarried. In that case, you are the immediate relative of a U.S. citizen. And if you enter the country with a visa, even if that visa has expired and now you're out of status, guess what? You could possibly qualify for adjustment of status despite being out of status. In that case, you'd be able to fix your status and stay in the United States, apply for your work permit, apply for a travel document. If you need to travel, that would be available for you. Now, there are other exceptions to the general rule that you have to maintain legal status in order to qualify for adjustment of status. So that is VAWA. If you are here in the United States, and in some cases, if you're outside of the United States, you have a history of being mistreated by, or you're currently being mistreated by a U.S. citizen or legal permanent resident spouse or parent. If you're under 21, under 25 in some cases, or a U.S. citizen's son or daughter who's 21 and up, then you could possibly qualify for VAWA. VAWA is called the Violence Against Women's Act, but despite the name, it is for everyone, not just for women, not just in marital situations, but in parent-child relationships, and that child is under 21. And also in the situation that the abuser or the person who's mistreating you is the child who is a U.S. citizen 21 and up. So, and this is for men, it is for women, it is for children. So if you are a man and you are in a situation where your spouse, whether it's a man or a woman, is mistreating you, this relief could be for you. And that's where it's very important to schedule a consultation. Because get this, it is not just for individuals who have been subjected to physical violence. It is also available to individuals who have been subjected to emotional, to verbal, to financial as well. And so if you're going through this, you need to schedule a consultation to determine whether you qualify for this relief, and we can get started to apply right away. Now with VAWA, it doesn't matter that you're out of status. What matters here is, did you go through this? Were you living with that spouse, that parent, that child, when you were going through the abuse in the United States? Are you one with good moral character? If this fits your profile, then you could very well qualify. And now when you're applying for VAWA, you can apply for this on your own. You don't need this abusive relative to be involved at all. It is confidential, and I make sure to safeguard my client's information. And we come up with a plan to make sure that none of the immigration documentation is sent to your home, that it is sent to the office where I collect your information. I work with the USCIS, I correspond with them, and get you through the process without your relative even knowing. This process can apply if you are with your spouse, or living with your parent, or living with your son or daughter who's 21 and up, or even if you are not living with them anymore, even if it's in the past. this, or even if it's currently happening to you, you can apply for this form of relief. So keep those questions coming. I don't see any more questions here. So keep your questions coming. I'm here to answer your questions. I'm both on YouTube and I'm on the Zoom. So keep putting those questions in the comments so that I can continue to answer your questions. I am looking for your questions in the comments. So put those questions in the comments. It can be anything that's immigration related. Now, another exception here is someone mentioned even with U status. So if you have received U visa, we call it U visa or the U status. If you have received the T visa or the T status, adjustment of status could be for you here. Now, the U status is for victims of certain crimes, and the T is for victims of trafficking. If you have gone through this and you have already received the status, then adjustment of status, even if you have a history of being out of status, could be for you. Even if you have criminal issues, you have an overstay, you cross the border without permission, there are waivers that are available for you to apply for forgiveness for this and still go on to get permanent residence. Now, let me explain a little about what the U visa is and the T visa. The U visa is for victims of certain qualifying crimes. If you've been the victim of any crime, you need to schedule a consultation to determine whether this could be for you. Because if it's for you, you could get the U status first and then eventually get a permanent resident. Now, the U status allows you to work in the US and obtain not only status for you, but for your relatives, like your spouse or your child. And if you're under 21, you could get it for your parents and your sibling who is under 18 and unmarried. So it is something that goes a long way to be able to help you to stabilize yourself in the United States, despite what you have had to go through. Now, if you do qualify for the U visa, is if you've been the victim of any crime that has resulted in your physical or mental abuse, you would be able to qualify for this. So that means that if you have been the victim of, for example, assault, burglary, if you have been the victim of domestic violence, stalking, this could be for you. But keep in mind that list isn't exclusive. I would want to evaluate what specific crime you have been the victim of and determine whether you could qualify for it this way. I help my clients to get the U status. And hi there, Cruz Familia, so nice to see you. It's been a while. Now, if you do qualify for this, what I do is I work with law enforcement to get them to provide a U certification. And once we get the U certification, it would be sent along with your application and additional evidence that you've been the victim of crime. And you would be able to get a work permit within months of applying. And then once you receive that, you would be placed on a wait list to obtain the U visa. The U visa, right now, the processing time is 10 years. So it is still taking a while to get it. However, keep in mind that you'd be getting a work permit while you wait for the U status to be approved. The T is similar, except it's usually in a case where you have been coerced, you've been convinced under fraud, you've been forced in the United States to work against your will, or you've been abused by your employer, you've been paid little or nothing, you haven't been paid at all. And in cases where you have been forced to do things against your will, like sex acts, this would be sex or labor trafficking, and it does qualify you for a T visa. The T visa allows you to get a work permit for the next 4 years and permission to live here. And then after 3 years, you would be able to obtain permanent residence through your T status. It also extends to family members who can also gain a path to permanent residence and citizenship as well. And then last is asylum. So if you have received asylum, then after a year of having asylum, you'd be able to obtain permanent residence. So those are some of the ways if that you'd be able to obtain permanent residence through adjustment of status. It is worth determining whether you qualify for these options, so feel free to schedule a consultation. You can do that by going to the link in my bio. It's going to take you to the website where you will see 3 ways to get in touch. So usually on a weekday, it would be the online chat. That's not open right now, but there's the contact form and there's a phone number. There's an after hours receptionist who is available to take your information, and then the scheduling coordinator will get back to you on the next business day. Now is the time to get in touch because the holidays are coming up and my schedule is filling up very quickly. So get in touch, schedule that consultation so we can talk about what your options are to stay in the United States, fix your status, and get permanent residence. Thanks so much for the love. I appreciate it. Now, I have a pre-scheduled live on Instagram. Instagram is where I post most of my videos. Well, actually, all of my videos. So it's Instagram and YouTube. So right now I'm also streaming live on YouTube, and I'm looking out for those questions on YouTube as well. So if you want to catch me on Instagram next and Facebook, you can go on Instagram to The Immigration Attorney. It's similar to this name. I am ST Law Office on Facebook. So you can catch me live on any one of those platforms. So Facebook is ST Law Office. And then on Instagram, I'm The Immigration Attorney. I will be there to continue this conversation and to continue to answer questions. So if you have a question, stars 130, hi there. If you have a question, and thanks so much, Fry, for sending the love. I appreciate it. So if you have questions, you haven't gotten a chance to ask those questions, hop on to Instagram right now. Just go to the link in my bio, click the Instagram button, and on YouTube, just go to Instagram and go to The Immigration Attorney, and you'll be able to join the live there where you can ask those questions. I'm also on Facebook at ST Law Office. I'll see you in a minute. I hope this information was useful. And remember, if you need that personal legal advice, because the information I've given you tonight is not personal legal advice. Oh, so Tia, I see you here. Can I file for my son if I'm waiting for my 10-year green card? So if you are a 2-year permanent resident, conditional resident, you would still be able to apply for your son. But keep in mind that in order for his process to be completed, they would have to see that you continue to be a permanent resident. But as a conditional permanent resident, you would be able to still apply for permanent residence for your son. Now, as a green card holder, in order to apply for your son has to be unmarried. Right now, if your son is under 21 and unmarried, it's right now there's no wait list. And so it's taking about 18 months to 24 months for that process. If your son is 21 and over and unmarried, it's taking 5 to 6 years. If your son is married, you'd have to become a US citizen to be able to apply for your son. All right, so I hope to see you on Facebook or on Instagram in a minute. I will talk to you soon. If I don't see you in a minute, I hope to see you on the live tomorrow. So he is 18 and he is here on vacation. So Tia D, if he's 18 and he's here on vacation, he would not qualify for adjustment of status, because remember that he would have to, at the time he's applying for adjustment of status, he would have to have a current visa number, and he would have to have an approved I-130. In addition to that, he would have to maintain his current status. Right now, that process, the adjustment of status process, is taking a while, and getting an approved I-130 is taking a while. And there would be questions here about whether he could maintain his legal status until his I-130 becomes approved. So schedule a consultation via TD. Schedule a consultation to evaluate your options, and let's see what can be done. You may qualify to apply for your son, but you would have to make sure that all the conditions are right for him to qualify for adjustment of status. If not, he would still qualify, but he'd still have to wait in his country. All right, so I'm heading on over to Instagram at The Immigration Attorney, or at Facebook at ST Law Office. So I hope to see you in a minute. If I don't see you there, I hope to see you tomorrow at around 9 p.m. Eastern time. If you don't see me then, you can catch me in a consultation. Just call, go to the website. It's stlawoffice.com. You can call, you can fill out the contact form, and on weekdays, you can even speak to the scheduling coordinator through the contact form. I'll see you in a minute. I'll see you tomorrow if I don't see you in a minute, or I'll speak with you in a consultation. Have a good night, and thank you so much for the questions. Tia D. Adams, I'm going to put the number in the comments. So go ahead and write down this number. It's 561-405-4889. You can also see it on other videos on my channel on YouTube. The Immigration Attorney on YouTube is the name of the channel. Go ahead, and then this is the website, stlawoffice.com. I hope to speak with you soon. All right. Have a good night, everyone. Thanks so much for your questions. See you in a minute. Bye-bye.